Senator Coons, you have about 9.5 minutes.
Great. Thank you, Mr. Chairman. I ask unanimous consent that letters from 8 different groups, organizations, individuals be entered into the record.
Without objection, so ordered.
Thank you. Judge Kavanaugh, we're at the end of a long day. And I'd like to take a few minutes and just explore with you a speech you gave last year, a speech at the American Enterprise Institute entitled The Constitutional Statesmanship of Chief Justice Rehnquist. There you called Rehnquist your first judicial hero, and you went on to discuss at length the 97 case Washington v. Glucksberg, in which the Supreme Court rejected a fundamental right to physician-assisted suicide. In Glucksberg, as you know, Rehnquist explained his belief that the only liberties protected by the Due Process Clause are those that are, quote, deeply rooted in the nation's history, legal tradition, and practices. You praised Rehnquist's opinion. You said, and I'm quoting your speech here now, the Glucksberg case stands to this day as an important precedent limiting the court's role in the realm of social policy and helping ensure the court operates more as a court of law and less as an institution of social policy, end quote. You further praised Rehnquist as a justice who, I think I'm quoting here, was successful in stemming the general tide of freewheeling judicial creation of unenumerated rights that were not rooted in the nation's history and tradition. The only conclusion I can draw from your praise in this speech last year of Rehnquist's substantive due process jurisprudence and his Glucksberg opinion is that you endorse this so-called Glucksberg test, which asserts the only substantive due process rights protected by the Due Process Clause, are those objectively rooted in American legal history and tradition. You even said yesterday in a similar exchange here that all roads lead to the Glucksberg test. So let me, in the few minutes I have left, ask a few quick questions about the implications of applying the Glucksberg test in a principled fashion.
Can I say one thing first?
I want to get a couple questions quick, and then, depending on the grace of the chairman, we may have an exchange.
Said the same thing Justice Kagan said when she was in this chair about Glucksberg.
And here's the most important thing about Justice Kagan's jurisprudence. She did not apply the Glucksberg test in U.S. v. Windsor, in Obergefell, or Whole Woman's Health. So the question I want to get to is, what would it mean to go and apply this test in a range of settings? So first, is judicial protection of the fundamental right to access and use contraception consistent with the Glucksberg test? It's a simple yes or no question, Judge.
I disagree that it's a simple yes or no question. What I've said here is that the precedent of the Supreme Court on that question, what Justice Alito and Chief Justice Roberts said about those precedents, Justice White's concurrence in Griswold as persuasive application of precedent. What is important to know about Glucksberg is it cited Planned Parenthood versus Casey as authority.
Yes.
As authority.
But on the specific issue of contraception, and I appreciate your having said those were correctly decided, I'm just trying to get clarity about if it were the Glucksberg test, well rooted in our history, legal tradition, and practices, would the court have ever reached those results on a fundamental right to access and use contraception, given the long history of states having statutes that prohibited access to contraception?
Well, as Justice White explained in his concurrence in Griswold, actually those laws had not been enforced for decades, but put that aside, the test in Glucksberg, as Justice Kagan explained when she was sitting in this chair, is a test that is guiding the Supreme Court going forward and has been cited in the precedent. It did not disturb any pre-existing precedent, indeed cited Casey as authority.
It did. So let's move on then to abortion, which was really centrally at issue in Casey. Is judicial protection of abortion rights consistent with the Glucksberg test, something deeply rooted in our history, legal tradition, and practices?
Again, I think it's important to underscore that the Glucksberg decision written by Chief Justice Rehnquist cited Planned Parenthood versus Casey as authority, which in turn reaffirmed Roe v. Wade.
But had it been the test at the time, the court would not have reached that result. In fact, you said at the AEI lecture, even a first-year law student could tell you the Glucksberg court's approach to unenumerated rights was not consistent with the approach of the cases Roe v. Wade, Planned Parenthood versus Casey. So we know the Glucksberg test, had it been applied, wouldn't have reached that same result. Let's move, if we could, from contraception, abortion, to intimacy. Is the Glucksberg test consistent with the court's historic decision, Justice Kennedy's decision in 2003, Lawrence v. Texas, which the court held the Constitution protects intimacy including same-sex intimacy between consenting adults?
Well, as the Supreme Court said last year in a broad majority, under the precedents that now exist, the days of treating gay and lesbian Americans as second-class citizens, gay and lesbian couples, or inferior in dignity and worth are over. That was Justice Kennedy, joined by Chief Justice Roberts, Justice Alito, Justice Gorsuch, Justice Breyer, and Justice Kagan. A statement for the Supreme Court summarizing, in essence, Romer, Lawrence, Windsor, and Obergefell.
But had the Glucksberg test been the sole test being applied during Lawrence, Justice Kennedy would not have reached the result he did. Let's move to the right to marry, if we could, for a moment, because this is the last case we're going to get through.
Windsor,
the right to marry is clearly rooted in our history, legal tradition, and practices. Yes, Judge? And we both know the landmark case, Loving versus Virginia, distinguishes marriage is clearly deeply rooted in our history, legal tradition, and practices.
Right.
But interracial marriage was not. In fact, it was barred in many states, probably longest in Virginia. And the Supreme Court struck an important blow in 1967 in striking down anti-miscegenation statutes. Last, what about same-sex marriage? If the Glucksberg test, where the test applied, is a right to marriage regardless of gender, deeply rooted in our history, legal tradition, and practices?
A couple things, Senator. I think Windsor and Obergefell talk about equality as well. So there's an equality principle, and as the court said in Masterpiece Cake Shop, summarizing all those decisions, a line of 5 decisions, all written by Justice Kennedy, Romer, Lawrence, Windsor, Obergefell, and Masterpiece Cake Shop.
Were they all correctly decided?
They're all, none of the 8 currently sitting justices have answered questions about any of those cases. As Justice Kagan said, no thumbs up or thumbs down on those recent cases. But what the court said in Masterpiece Cake Shop is the most recent statement of the Supreme Court for a broad cross-section, a large number of justices on the Supreme Court. And I think I'll leave it by referring you to that statement from the Supreme Court.
Here's my core concern. This quote, what you chose to do in a speech last year in front of AEI was to lift up this Glucksberg test. What you chose to say yesterday, all roads lead to the Glucksberg test, gives me pause and concern. If you feel I've somehow misquoted you in the American Spectator article, if you feel I've somehow misquoted you here, I expect we'll have a chance through some written exchanges to give you an opportunity to further clarify that, given the limitation on my time now. But in what I've read about how the Glucksberg test has or hasn't been applied, the ways most critically in which Justice Kennedy himself rejected the Glucksberg test in his opinions in Casey, in Lawrence, in Obergefell, I think the Glucksberg test is better at rejecting claims of constitutional rights than it is at accepting them. And I think it's a blunt instrument. And I'm concerned that it may reveal an enthusiasm for a test that would permit the continued exercise of government power in ways that frankly would blow up all modern substantive due process. If applied rigidly, it would blow up precedent in contraception, abortion, protection from sterilization, marriage, a whole range of areas. These are settled precedent. But those of us who sit trying to decide whether you should be the next justice and take Justice Kennedy's seat have to ask ourselves what your views would be. And in this recent speech where you cite your first judicial hero, Rehnquist, in articulating the Glucksberg test, I worry that you reveal you don't share the view of our framers, in particular the 14th Amendment framers, who understood constitutional rights to exist in significant part to right historical wrongs, not to ignore them or entrench them. Our Constitution's protection for people who are vulnerable or marginalized or just different from the majority is what makes us a beacon to the rest of the world, where there are so many countries where minorities or those who dare to live their lives differently are marginalized or oppressed. And it is exactly this Glucksberg test that worries me most, because it excludes all such people from the circle of constitutional concern and protection. I'm troubled, Judge Kavanaugh, if you don't understand that as the driving, animating force of our constitutional culture. And this is a test that, in my view, is just not up to the task of vindicating our country's greatest ideals. Thank you.
If you feel you want to comment, go ahead, and then I'll call on Senator Lee.
2 points. Justice Kennedy joined Glucksberg. Justice Kagan cited Glucksberg repeatedly when she was in this chair.